At 9:33 a.m. Eastern Standard Time, federal prosecutors received a formal response from Melania Trump's legal team that significantly altered the direction of the government's case against Ivanka Trump. The message was brief and definitive. Melania Trump declined the government's cooperation offer. With that decision, a key opportunity for sentence reduction in Ivanka Trump's federal fraud case was eliminated. The proposed agreement followed a standard prosecutorial framework. In exchange for truthful testimony regarding 3 specific financial transactions she personally witnessed, the government would recommend leniency during Ivanka Trump's sentencing. Such agreements are common in complex financial prosecutions, particularly when insider testimony can corroborate documentary evidence. Melania Trump chose not to participate. The legal consequences of that refusal are substantial. Ivanka Trump currently faces federal charges that carry an estimated sentencing range of 11 to 19 years in prison. Had the cooperation agreement been accepted, sentencing guidelines indicate that range could have been reduced to approximately 6 to 10 years. The difference represents not only a legal shift, but a life-altering one. Shortly after the refusal was delivered, prosecutors began receiving new material from independent sources. Within minutes, a Secret Service agent submitted a voluntary witness statement. Additional evidence followed, including time-stamped text messages and preserved screenshots of a social media post that was later deleted. Collectively, these materials documented reactions inside the Trump family immediately after the cooperation refusal. This development is not a personal dispute or a family disagreement. It is a pivotal moment in a federal prosecution involving serious allegations of bank fraud, tax fraud, and conspiracy. Cooperation was offered, declined, and the case now proceeds without it. The legal process has moved into its final phase. Melania Trump's involvement in the investigation began on April 15, 2024, when prosecutors authorized subpoenas for her personal financial records. These requests were not exploratory. Her name appeared as a signatory on multiple accounts connected to loan applications now alleged to be fraudulent. The documentation placed her within the operational structure of key Trump Organization financial activity between 2018 and 2022. By July 2024, Melania Trump had been questioned twice under subpoena authority. At that stage, she was classified as a witness, not a target. Prosecutors believed she possessed first-hand knowledge of financial interactions between the defendant and Ivanka Trump. These interviews were conducted as proffer sessions, designed to assess the value and credibility of potential testimony. During these sessions, Melania Trump acknowledged being physically present during meetings in which Ivanka Trump was allegedly instructed to falsify financial documents. According to investigators, she was not merely nearby, but seated at the table during discussions involving asset valuations and loan representations. This placed her in a unique evidentiary position. On October 3, 2024, prosecutors formally charged Ivanka Trump with multiple counts, including bank fraud, tax fraud, and criminal conspiracy. While the documentary evidence was already extensive, prosecutors viewed Melania Trump's testimony as a decisive factor that could eliminate reasonable doubt by confirming intent and coordination. In December 2024, a formal cooperation offer was delivered. Prosecutors outlined specific testimony required and the sentencing consideration that would follow. Over the next several months, Melania Trump's legal team requested extensions and raised privilege arguments. Those arguments ultimately failed under established law, as spousal privilege does not protect business communications involving third parties. Her refusal finalized a critical turning point in the case. The cooperation agreement focused on 3 financial events that prosecutors consider central to establishing criminal intent. The first involved a $47 million loan application submitted to Deutsche Bank. The meeting took place at Mar-a-Lago and was attended by senior Trump Organization personnel, including Ivanka Trump, Melania Trump, and 2 accountants. Evidence confirms the meeting occurred, including calendar records, emails, and accountant testimony. Investigators allege that during this meeting, Ivanka Trump was directed to use outdated property valuations from 2017 to inflate asset values in a 2019 loan application. One accountant has already testified to this instruction. Melania Trump's testimony would have provided independent corroboration. The second transaction concerns an Internal Revenue Service audit of Trump Organization tax filings. Prosecutors recovered a series of text messages between Ivanka and Melania Trump, in which Ivanka sought guidance on handling asset disclosures. One message referenced the use of a Cyprus structure to conceal beneficial ownership. Prosecutors view this as evidence of sophisticated financial concealment. The third transaction involves offshore accounts located in Cyprus and the Cayman Islands. Bank records show Melania Trump listed as an authorized user on accounts effectively controlled by Ivanka Trump. Between 2018 and 2022, approximately $18.4 million passed through these accounts. The origin and purpose of these funds remain a central issue at trial. Prosecutors possess extensive documentation, but testimony explaining intent and coordination is critical in financial crime cases. Melania Trump was uniquely positioned to provide that explanation. Her refusal leaves gaps the government will now address through documents and other witnesses. Following the refusal, prosecutors documented a series of reactions that they classify as evidence of consciousness of guilt. At 10:15 a.m., a Secret Service agent assigned to the defendant submitted a voluntary sworn statement describing a phone call overheard shortly after the cooperation decision. According to the statement, the defendant was heard shouting accusations of betrayal and expressing anger toward Melania Trump for refusing to cooperate. The agent reported escalating profanity and the sound of a mobile phone being thrown against a wall, shattering on impact. The statement was submitted without solicitation, which prosecutors consider significant. Additional evidence includes a text message exchange between the defendant and Eric Trump. The messages, time-stamped later that morning, urged Eric Trump to pressure Melania Trump regarding her decision. Prosecutors interpret this as an attempt to influence a potential witness. A third piece of evidence involves a social media post published and deleted within 17 minutes. Screenshots preserved by investigators show language warning of consequences for disloyalty. While later removed, the post is now part of the evidentiary record. In federal prosecutions, attempts to intimidate or pressure witnesses are taken seriously. Such behavior is often introduced to demonstrate awareness of wrongdoing rather than innocence. Prosecutors argue that these reactions reinforce the importance of the testimony Melania Trump declined to provide. Ivanka Trump's legal exposure is governed by federal sentencing guidelines, which rely on structured calculations rather than discretion alone. For bank fraud involving amounts exceeding $10 million and executed through sophisticated means, the guideline range is approximately 8 to 12 years. While multiple counts exist, related offenses are typically served concurrently. Additional charges include tax fraud and conspiracy. When combined, Ivanka Trump's realistic sentencing exposure falls between 11 and 19 years. This range represents the baseline without cooperation or mitigating factors. Federal guidelines allow for sentence reductions when substantial assistance is provided. Cooperation by a close insider, even a family member, can result in reductions of 20 to 40%. Had Melania Trump testified, prosecutors estimate the range could have dropped to 6 to 10 years. Because no cooperation occurred, prosecutors now plan to recommend the high end of the guideline range. Federal judges follow such recommendations in the majority of cases. There is no parole in the federal system, meaning most of the sentence would be served. The refusal did not merely remove a potential benefit, it reshaped the sentencing posture entirely. Ivanka Trump is the third Trump family member charged in related financial investigations. Prosecutors argue this reflects a broader organizational pattern rather than isolated misconduct. Similar methods appear across cases: inflated valuations, offshore accounts, concealed ownership, and coordinated documentation. Donald Trump Jr. faces charges involving shell companies and foreign income concealment. The defendant himself faces multiple business fraud counts. Prosecutors view the repetition of techniques and shared infrastructure as evidence of coordinated activity within the Trump organization. In organized financial crime cases, prosecutors assess whether a business functions as a vehicle for repeated illegal conduct. When multiple family members participate using the same systems, courts often consider it a continuing criminal enterprise. Investigators have tracked funds across 17 countries, reviewed millions of documents, and interviewed more than 130 witnesses. Melania Trump was the only individual with direct exposure to all three cases. Her testimony could have unified the narrative. Without it, prosecutors will rely on documents, records, and third-party witnesses. The trial is scheduled to begin on June 9, 2026. Pre-trial motions conclude in March, evidentiary hearings occur in April, and final witness lists are locked in May. Jury selection begins in early June, followed by opening statements. The prosecution plans to present its case over 2 weeks, relying heavily on documentary evidence, financial experts, and cooperating witnesses from banks and accounting firms. The defense will follow, with closing arguments expected in mid-July. Although Melania Trump will not testify, prosecutors maintain the evidence is substantial. Financial records, emails, and bank documents form the backbone of the case. In white-collar trials, juries often rely heavily on written evidence rather than personal testimony. The legal process now moves forward without delay. The cooperation window has closed. The evidence will speak for itself.